Welcome to the Court Gallery. Today's fascinating double feature takes us to Washington State. First up, we visit Judge Bashor in Cowlitz County for a messy utility dispute. A resident claims her water was maliciously shut off for 6 whole months, but a city utility worker soon exposes the real reason for the dry tap. Next, we travel to Thurston County, where Judge Buckley handles a suburban nightmare. Former hiking buddies turned bitter enemies are fighting over a destroyed privacy fence and a hefty small claims lawsuit. Was a single unread text message enough legal notice to tear down a boundary fence? Will the judge make them pay? We're about to find out right now.
So we're here in 2016-41808. I'm Judge Bashor. Before we get started, I just wanted to put on the record, in case anybody has any issues, this case was originally started, it looks like, by Mr. Madsen through Timberland Legal Services. My wife is the executive director of that agency. I typically don't share those cases. I don't have any mandatory recusals. And if the parties are uncomfortable with me hearing it, I will defer to have another judge here, but I want to put that on the record.
I don't have any problem with Your Honor hearing the case.
Okay. Ms. Grubb, any objection to me hearing the case?
No, my new lawyer was supposed to come to the case, I guess, for this hearing, because I got a lawyer for this.
Who is that?
It's supposed to be Tacoma lawyers.
Your Honor,
Tacoma pro bono.
she had an attorney appear in a separate eviction action that is set.
I have 2 different lawyers, Your Honor.
Okay, in this case, the only one I had was Mr. Madsen, who has withdrawn.
Yeah, I got a case with the Tacoma pro bonos. Yeah, he was supposed to talk to me prior to this case, just before we went on. I don't know what happened with that.
And I haven't heard anything on that, Your Honor. I haven't received a notice of appearance.
Okay, and I haven't heard anything from anybody. No one's contacted the court. I'm familiar with that office, but
If I may say something, Your Honor, can we continue this after I talk to my lawyer?
well, we were set for trial today. This was set just a few, 2 weeks ago? A week ago?
Readiness was last week, Your Honor. It was set before.
Prior to that. Okay. Yeah. So I don't know, Ms. Kazimir, what's your position on a continuance on the matter?
We would strongly object, Your Honor. There's this is a pretty straightforward issue, and we've, got a city employee here that we've subpoenaed, taking her time away from her work to testify here today. It's been set for trial for some time. Ms. Grubb filed this action some time ago. Her attorney withdrew some time ago. She's had plenty of time to obtain new counsel before today's date, and apparently chose to do so a week before trial. So we would like to proceed today. I think this needs to get taken care of.
Right. Well, Ms. Grubb, given the nature of this case, I'm not inclined to continue it. This is not an eviction case, a landlord-tenant type case in the normal sermon events. This is really your request for an injunction and some other relief. And so I think that's where we're at this point.
If I may, Your Honor, I just got this attorney. They just haven't contacted me, but I contacted them and talked to them, and they told me that they were gonna set everything up to talk to you guys today. I guess I don't know what happened to that. I'll have to call them. It took 2 weeks to get a hold of them.
Okay. Well, they haven't contacted the court, and they haven't contacted apparently Ms. Casimir's office. This was
Yeah, it's
set to go
the
through.
Tacoma pro bono, I think. Sorry.
Mhm. Yeah, I can give you this. You may have another eviction case going, which is not this case, and that may be
No,
what
I
they're
have
involved in.
another lawyer for this one. I don't know. I just got them through Northwest Justice, referred me over to them.
Okay. Well, my problem, and this thing was set for trial, looks like back at the end of July. So about 20 days ago. My concern is we've got an injunction that's in this case, and continuing that on is, am I understanding that the specific injunction was really turn the water on? Is that?
Yeah, the issue in this case is essentially that she's claiming the water was turned off. The injunction required the landlord to direct the city to turn the water back on.
Okay.
And if I may say, Your Honor, last Tuesday it got turned off again. I have no water again.
Well, that's interesting. Do we know why?
Because she won't transfer it into my name so I can pay the bill.
Yeah, that's essentially the issue here today. Non-payment of the water bill and whether that water was intentionally cut off by the landlord or not. So that, I mean, that's really the issue that this trial is about.
Okay. So what happened to get the water turned on? I guess that's
Bill
concerning.
exceeds $1,400 at this point. Ms. Scrub has made no payments on the water bill since January.
Okay. But wasn't the city or your client directed to get that turned on?
My client was told to direct the city to turn the water on. It was turned back on after the injunction was entered, and my understanding, which Ms. Fleming is here to testify about, is that the city both times turned it off for non-payment.
Okay, well, that raises other issues in the case. We can go ahead and go forward, but I think that's a problem if we're not complying with the injunction.
Well, the injunction specifically says direct the city to turn it back on. If the city refuses to do that, my client has no control over that.
Well, that may be arguable. That's probably not a very strong defense to violation of an injunction. But we can go ahead and move ahead here. So, Ms. Grubb, I know you had an attorney who drafted this up. Do you have any testimony that you wish to present on behalf of this case, ma'am?
I paid
Okay, well,
the water
hold on
bill.
a second.
Oh.
If I can have you raise your right hand for me, please.
Oh.
And ma'am, you promise to tell the truth today under penalty of perjury.
Yes, I do, Your Honor.
Okay, and you are Janice Grubb?
Yes.
Okay, Ms. Grubb, if you want to go ahead and tell me what's going on in your case.
I paid rent up until January until my landlord had my water turned off. I went to the water company to try to get it transferred into my name, and they wouldn't transfer it in my name without a lease. Because she's trying to say I forged a letter that her secretary asked me to come pick up, and I have text messages showing that she asked me to come pick up the letter. And now she's saying I forged a letter to get my water put in my name, and that's ridiculous. And so they still wouldn't put it in my name, and I had no water for 6 months. And then it went to the exceed of whatever they're saying it is, of how much it is. I don't see how when I had no water. And then the judge ordered it to be turned back on, and then this last Tuesday it got turned off again.
She can't turn it off herself the first time.
And I think she came and turned it off herself because the guy that came out and turned my water back on told me it was kind of weird when he opened the water thing and there was a lock on my emergency side and not their side. So I'm trying to figure out what to do about that, because I mean, he said that's not normal for it to be locked on my side, on the emergency side. For a pipe burst in my house, I can fix it or whatever. It would have been locked on their side.
Their text don't make that mistake.
And Your Honor, I would object as to hearsay.
Well, I'll sustain on that. Can't tell me about what other people have told you on the case, other than that Ms. Soto is a party to the case. So I will strike that last comment about what the water folks said. Anything else, ma'am?
Just all I was trying to do was get a lease so I can be able to live here. I was paying my bills up until January. Everything was paid. I had no problem with paying my bills. She said I didn't make enough to live here, but my bills were paid. I don't see the problem. I really don't. Is all I can say.
Okay. Ms. Kazmar, any questions that you have?
Yes. So, Ms. Scrub, is it your testimony then that that you have not had water service to the home since January?
Yes.
But you also testified that the water was just turned back off. So was there water service restored at some point?
It got turned back on in June.
And how
And
did that
then-
occur?
Court ordered it to be turned around.
Yeah, it was court ordered to be turned back on in June. And then
Your Honor, there's appears to be someone in the room with Ms. Scrub telling her what to say. I'd ask that.
sorry, it's my boyfriend. He's been here through all this too. My apologies.
Okay, so he'll need to exit the room, ma'am. It just needs
Okay.
to be just you,
Sorry.
and he.
Sorry. He left.
If you want to call him as a witness, you can do that, but that's a separate issue. But I need to have
Okay.
you just testify from yourself at this point.
My
Go ahead.
apologies.
Ms. Kazmar. It's okay. Ms. Kazmar?
Okay, so your testimony is that the water was turned back on in June after the injunction was entered?
Well, when the judge told us that it needed to be turned back on, it got turned back on that day that the judge said to turn it back on. I called and they turned it on they came out and turned it on like the next day or two after the judge said that.
And then what day was that water turned off again?
Just this last Tuesday.
And so from January to June, your testimony is that you did not have any water service?
No, I did not.
I have no further questions.
All right. Anything additional, ma'am?
No, just struggling, not having no water, being able to give my child a shower and have drinking water to be able to drink. It's been a rough time, really bad. And it makes it hard on my son, and he's only 12 years old.
And ma'am, did you have any additional witnesses you wish to call?
My boyfriend, if I may.
If you want to call him, you can do that, and you'll need to be on camera, and you'll have to ask him questions. He can't just tell me his story. So you'll need to ask. You want to have
Okay.
him come back?
Yeah. Just 1 second. Right. Just a second. Sorry. He's coming. He's got to get a shirt on.
Okay.
He's coming right now.
Okay.
I have to ask him questions.
You will, yeah. And I'll need to have him on camera and.
Okay.
Hello.
All right, good afternoon, sir. If I can have you raise your right hand for me, please. Can you promise to tell the truth today under penalty of perjury?
Yes.
Okay, can you tell me your name, sir?
Joseph Burley, the third.
And if you could spell your last name for the record?
Burley.
Thank you. And then did you have some specific questions you wanted to ask of Mr. Burley?
Yeah. Was our water turned off in January to the time that it got turned back on in June?
Yeah, he was.
And when did our water get turned off again?
Last Tuesday. And from my understanding, when I guess the bill was due in January or whatever. As far as we know, our old roommate paid the water bill, and it was like $186 or whatever, and then it was turned off for, like I said, 6 months, and then all of a sudden it's an $1,100 bill now. Which don't make no sense.
Okay. All right, boy, did you need to answer questions, sir?
Yeah.
Anything else, ma'am?
No.
Okay. Cross-examination?
I have no questions for this witness.
All right. Thank you, sir. That's all we need from you today. Any additional witnesses, ma'am?
Not here with me today, no.
Okay. All right, then Ms. Kazmaier.
Thank you, Your Honor. I'll call Sheila Soto. That's my first witness.
So Ms. Soto, if I could have you get your camera facing you so we can see you. All right, if you could raise your right hand for me, please, ma'am. And you promise to tell the truth today under penalty of perjury.
Yes.
And if you could tell us your name and spell your last name for the record, please.
Sheila Soto, Soto.
Thank you, counsel.
Thank you. Ms. Soto, do you manage the property located at 249 Oregon Way?
Yes.
And do you do that on behalf of the owner, James Marsh?
Yes.
Okay. And in December or January, did you go out to the property and turn the water off?
No.
Did you at that time put a lock on the water of any kind?
No.
Did you contact the city of Longview and tell them to turn the water off?
No.
Okay. When is it your understanding that there was water service to the property from January to approximately March?
Yes, I believe so.
And did you in June, or excuse me, did you at any time in August this month go out to the property and put a lock on the water services?
No.
Did you in August of this year contact the city and request that they shut the water off?
No.
Okay. I have no more questions for this witness, Your Honor.
All right. And Ms. Grubb, any questions you have of this witness?
As far as I can say is, I wanted to see or ask why sorry, I'm new to all this, so did you ask the water company or tell the water company that we forged a letter?
Did I? Sorry, go ahead, Meg.
I'm going to object as to relevance. The issues are whether landlord intentionally cut off water.
Well, I think that has some limited relevance. I'll let her answer the question.
No.
There's evidence that from the water company saying that she said that we forged it.
I'm going to object.
So you'll just need to ask questions, ma'am. You're not testifying, so you just need to ask her questions.
Did you ask the water company to come out and turn our water off?
No.
I don't have any more questions, Your Honor.
Okay. Any redirect?
No, Your Honor.
All right. Any additional witnesses?
Oh,
Any additional witnesses?
sorry, Your Honor. Yes, I'll call Miss Fleming at this point. Diamond.
And Ms. Fleming, if you could unmute yourself.
The camera will take a little bit to register. There we go.
There we go. All right, ma'am. Can you hear us okay?
Yes.
All right. If I could have you raise your right hand for me, please. And you promise to tell the truth today under penalty of perjury.
Yes.
All right. And can you tell me your name and spell your last name for the record, please?
Diamond Fleming. It's Fleming.
Thank you. Counsel.
Morning, Miss Fleming, or good afternoon, excuse me. Can you tell me where you're currently employed?
The city of Longview,
And what department do you work in?
the finance department.
Okay. Do you handle utility counts as a normal part of your job?
Yes,
And are you familiar with the utilities account for the property located at 249 Oregon Way?
yes.
Okay. Can you tell me if the water was if water services were shut off to the premises in January of 2026?
Correct.
Were services actually terminated, or was water continued to be provided?
The water was shut off, but there was water usage. So it appears to be somebody must have turned it on. So there was extra water usage after we had turned it off.
And why was it turned off?
It was turned off because nobody had signed up for service.
Okay. And was that because the prior tenant at the residence had requested a disconnect?
Yes,
Okay. And when was the water shut off again in March?
yes, it was shut off again for non-payment of the water used.
Okay. And when did the landlord or Miss Soto direct you at that time to shut the water off?
No,
So that was the city's decision to turn off the water.
yes,
Okay. And then in June, after this court entered an injunction, was the water turned back on?
the water was turned back on 5/26.
Okay. And do you know how that occurred?
It was after hours, so I believe it's not noted who called, but someone called our after hours saying that they had a court order that we were required to turn the water back on.
Okay. And so
So
after, sorry, go ahead.
the after hours dispatch turned it back on for them.
Did water service remain active until last week sometime?
Yes.
Okay. And why was it shut off last week?
Because after we had turned it on, you have to wait a certain number of days before you can notify by mail of a shut off legally. So we had to wait for the timing process that it could go through to shut it off for non-pay again.
Okay. So it was ultimately shut off due to continued non-payment.
Yes.
Do you have to be the account holder to make a payment on a utilities account?
No.
And has the city received any payment from Ms. Grubb on this account at any time between January and now?
That wasn't something I was supposed to look up. So I'm not 100% sure on that.
Okay.
From what I can recall, no, but there's a long history of a lot of months. So without looking at the actual ledger, I can't tell you right now.
Okay, that's fine. At any time, did Sheila Soto tell the city to turn off the water?
No.
Okay. I have no further questions.
Can I ask one clarification question?
Yes.
Ms. Fleming, I assume that you sent a letter to somebody about a shut off. Who would that have been sent to?
That would be all within the account. So that would have been mailed to the owner. I believe the owner's listed in care of Sheila Soto. I don't have it in front of me.
Okay, thank you. Did it raise any additional questions, council?
No, Your Honor.
And I may be a little left over here. Miss Grubb, any questions you have? Miss Fleming?
Yeah. Excuse me. Hi, good afternoon. I just wanted to ask, what was I going to say? Did Sheila call or email you guys and tell you guys that I forged a letter that she wrote?
I know nothing about any forging, no.
Because it's in the text. It's in text messages on paperwork.
Ma'am,
that was filed.
just ask her questions.
That wouldn't really pertain to anything that I would have any say over.
Well, ma'am, that wasn't a question. That's not a question before you, ma'am. Please wait for another question, please.
How was the water turned on in March or whatever, and it was turned off again recently, but we didn't have water for 6 months? How is it possible to have no water for 6 months, excuse me, and then the water's turned back on in March? That makes no sense to me.
Well, we don't have any record of turning it on ourselves. So the meter is on the property. It wasn't turned on by the city of Longview, but it did have water usage that we had to bill for.
How would it have had water usage if it was locked and turned off on the emergency side?
It wasn't locked in January. It was locked at a later date.
I object to that because there was a lock on it.
So you just ask questions, ma'am. This is
Yeah.
just questions of this witness.
I don't know what else to ask. I'm new to this stuff.
I understand.
I'm good,
Okay.
thank you.
Okay, thank you. And Ms. Kazmaier, any redirect?
Just to clarify kind of the issues. So Ms. Fleming, in January, your testimony is that the city did shut the water off, correct? And that someone, and you don't have any record of who, turned the water back on, and so there was usage that the city had to bill for. Is that correct?
Right.
And then later in March, it was turned off for non-payment of that bill.
Yes.
Okay. No further questions, Your Honor.
Okay. Any additional witnesses?
No, Your Honor.
Okay. And Ms. Grubb, did you have any rebuttal witnesses or rebuttal testimony that you wanted to give at this time? You're still muted, ma'am. I can't hear you.
That my water was off for 6 months and it wasn't turned back on in March, and that we never messed with the water at all. The only time the water got turned back on is when the city came out and turned it back on and cut the lock that I have right here.
Yeah, I'll object to that, Your Honor.
Sustain the objection to the last comment. Or anything else, ma'am?
No, that this is all ridiculous. And
Okay.
I wish we had water because I would have paid the water, but she wouldn't let me transfer it in my name, and the city told me I couldn't pay it without it having a lease in my name.
Okay. Does that raise any questions, Ms. Kathmeyer, on rebuttal?
Did you ever go to the city of Longview and attempt to make a payment on the bill?
It was under my friend Tasha's name still when she was still living here.
Okay,
And she paid the last bill until up until January, and then Sheila wouldn't give me a lease to transfer it into my name, and that's when it got turned off.
Okay, so two separate issues. So did you attempt to have the water put into your name?
Yes.
And that ultimately did not happen, correct?
No, because she won't give me a lease.
Okay. Did you, after that time, attempt to go to the city and make a payment on the utility bill for the property?
They told me I couldn't because it wasn't in my name.
No further questions, Your Honor.
Okay,
They said the account was closed.
okay. Anything else, ma'am?
No.
Okay. All right, so this is, any argument at this point?
If I could just briefly, Your Honor.
Sure.
This action is filed under 5918-300, which states that a landlord cannot intentionally cause the termination of utility services to the property. In this case, we have Ms. Fleming testifying that the water was shut off in January due to a disconnect request from the prior tenant, that Ms. Grubb was unable to transfer the utilities into her own name. Water was turned back on. Ms. Grubb failed to make any payments on that account. Ms. Fleming has testified that you don't have to be the account holder to make a payment on the account. I think that it's clear that she could have gone at any time to make a payment on the account. Ms. Fleming's also testified that at no time did Ms. Soto tell the city to turn it off, request that the city turn the water off. Once the injunction was entered, the city turned the water back on, and ultimately, per their policies, turned it back off for non-payment last week. And again, testified that Ms. Soto did not direct them to turn it off. So we would ask that Your Honor dismiss this action. I will note there is $1,100 in the registry that Ms. Grubb paid into the registry some time ago. We would ask that that be released to the landlord to pay to the city to cover at least a portion of, if not all of the bill at this time.
Ms. Grubb, any comments you'd like to make at this time with regards to the outcome of the case?
I don't think I should have to pay for water that was off. I really don't. I mean, I didn't have no water for 6 months. It was ridiculous. We couldn't shower. We couldn't drink water. I mean, my poor child couldn't even take a shower for school. We went across the street to go to the trailer dump thing just to get water and almost got arrested because they say we're not trailers and we can't go over there and get free water just to dump our toilet. And it's ridiculous that this is even happening right now. Is all I can say. It's just been a struggle really bad. And I tried to talk to the city about even putting it in my name, going and paying it. And they told me the account is closed. Nobody could pay it. Nobody could do nothing. They closed out the account. Sheila closed out the account. Sorry.
Your Honor, I object to any new testimony that wasn't brought up during her testimony.
I'll sustain that with regards to that. I'm curious. I see there's some money sitting in the clerk's account. I don't know why that's there.
It was deposited as a show of good faith during settlement negotiations, Your Honor. We're just simply asking that that money be basically paid to the city, whether that happens through landlord or directly to the city.
I don't know that I have any jurisdiction to do that. Unless there was some agreement to that effect. I just have an agreement for money deposited in the Brooks account.
I can always get the money out and pay it myself. If that's the case.
And there was no order, put anything into the account. So I don't, and that's something that was between the parties.
It was an attempt. It was deposited as a potential rent payment in we were considering settlement. It was deposited as a show of good faith when Mr. Madsen was on the case.
Well, I don't know that I can consider any settlement negotiations as part of the case. This is an interesting case because reading back through and trying to figure out what we were on for today, there was an argument about Ms. Soto not being a proper party. Review of the statute. She under the definition of landlord, she is a landlord under the definition of RCW 5918 030, I believe it is.
Yes.
So she's a proper person as a defendant in the case. The relief that was requested in the case was finding Ms. Grubb to be a tenant. It would seem to me, based on the research that I've done and looking through the statute, she is a tenant, but not under the Real Estate Landlord Tenant Act. She would be a tenant at will, essentially. But she doesn't fit the definition of a tenant under 5918-03034, which requires to be under a rental agreement. So we don't have a rental agreement here, at least between, and that's one of the issues. If we had one, we probably wouldn't be here, but we don't. So I don't think she qualifies as a tenant under that statute. I am concerned about the injunction issue because the language of the injunction was that the landlord or defendant, essentially Ms. Soto, would be direct the city to restore water service, which just sounds like that was done. And from what we heard today, that the letter that would have noted a termination would not have gone to to Ms. Grubb. It would have gone to Ms. Soto. And I guess that's concerning to me because that's allowing this to lapse, which is very similar to not keeping it restored. So that's a bit problematic. But I don't think under the basis of a tenant at will that I could order an ongoing injunction. So I'm going to deny that. And under the loss and suffering, I think I have to get into one of these other two before I can get there. There were discussions from what I could see and from what I saw in the text messaging that was provided. It wasn't actually introduced into evidence, but the only agreement was that they were going to consider an application to become a tenant, which apparently wasn't accepted. So I can't find a breach of contract. And I don't know that I can really do anything with a third claim either. So I'm going to deny relief under those three claims. I'm not going to order that the money in trust be paid to anybody. If there's any claims for damages or something, that's probably needs to be a small claims or something else. But that at this point, that was money put into trust on as part of some settlement negotiations that this court's not party to. Didn't order that, and it's obviously at this point still Ms. Grubb's money. So, but I will dismiss the case at this point.
Thank you, Your Honor. Do you want me to prepare an order?
I think I'm going to save everybody some money. I'll just do a bench order that denies the request and dismisses the case. I think
Okay.
that's probably effective and saves everybody a lot of extra work. And then you folks are going to sort out all the rest of this outside of here. Okay.
Okay. Thank you, Your Honor.
All right. You're welcome.
Ms. Grubb, you're muted.
Ms. Grubb, did you have anything else you wanted to tell me?
Yeah. Is there any way I can get my water turned back on? Because
Well,
I
ma'am,
didn't get no notice on my door that my water was getting turned off either.
Okay. Well, at this point, you're not a tenant of that property under the Landlord Tenant Act. I don't have a basis to order that going forward.
Okay.
So you're gonna have to work with Ms. Soto if they want to turn into a tenancy. You can talk with them and their counsel. If they don't want to do that, then you'll have other decisions to make.
Okay.
I'm not ordering you to turn over that money, so that money's yours. Come to the clerk's office and give it back to you.
Okay. Thank you.
Okay. All right. So I'll do an order dismissing.
Okay, Ms. Neveling, sorry. And Ms. Nelson, Ms. Romo. Sure.
Oh, she's my witness.
Okay, did we get the speaker issue worked out so we don't have feedback?
I hope so. Is that better?
Not hearing any feedback.
Thank
Good.
you.
Thank you.
You're welcome.
All right. My understanding is that Ms. Nelson, Ms. Romo, Ms. Neveling are immediate neighbors. They used to be fast friends and hiking partners, and now there's a fence dividing them. Is that summation correct?
There was a fence until they took it down. Yes, there was a fence dividing us.
Okay.
It's a beautiful fence.
All right, and Ms. Neveling, you're seeking damages in the amount of $3,221.31.
Yes, Your Honor.
And that's for removal of a fence?
It is a replacement cost because we physically can't rebuild the fence because of what they built is a 6-foot tall metal fence. They left all the cement in the ground. And so the 3 estimates were just basically the value of the fence that they tore down.
Okay, and that's the 3221.
Right, including the landscaping that was damaged. And then my cost for service, my cost for copying, my court costs.
Okay, I may have you run through all that a little bit. So tell me about this fence. And remember, I've read what
Right.
all of your
Yeah. So I
files.
came home on March 26th after hiking, and I pulled into my driveway and I just saw my fence was completely torn down, thrown on my lawn. I approached the fence company. I said, "What's going on?" They said that the neighbors told them to tear it down. I said, tell the neighbors to come down. I went into the house and I called this is another neighbor of ours. I asked if she would come as a witness for the conversation. And Vicky came down and we, went into the whole conversation of what are you doing? What's going on? She said, "Oh, well, I sent you a text. Did you not get it?" I said, "No, you guys have been blocked since last summer. You blocked email, you blocked text. I didn't get anything." She started to describe what they're doing. I said, "How come you didn't have the fence company knock on my door? How come you didn't send a certified letter?" And she basically went into a spiel of trying to sell me on their brand new fence. My fence was only 7 years old. It was perfectly fine. And short story is, I said, "You come onto my property, you trespass, you've destroyed my personal property, and you need to go ahead and pay me for it." She offered to have her fence company rebuild it, which is physically impossible because my fence was cut off in sections and my fence posts were cut off at the ground, again, all thrown on the ground. And so I said, "Well, then I need you to agree that you will pay me for the value of what you've done." And Vicky Romo said in front of my witness, "I'm sorry, I apologize, I made a mistake, I never should have told the fence company to tear this down." And I said, "Are you agreeing you will pay me for the value of the fence that you tore down?" She said, "Yes." And then my witness can tell you, or I can tell you what my witness said. So this is what I'm here witnessing, Vicky. This is what I heard. And Vicky agreed. We went our separate ways. Then I went back and I was talking to the guys actually doing, because the guys weren't there when I pulled in, just the holes and their fence posts were there, the metal posts. I went back and I looked at the string line. And so I was talking to their fencing people and I said, well, how do you know where to even put the fence? And they kind of looked at me. So I think they were from Croatia. They didn't speak English very well. And I said, well, where is the property line marked off? And they said, it's not. I said, who put up the string line? They said they weren't sure. I said, do you know where the property line is? And they said, no. And I said, where your string line is actually my property, because the fence they tore down had been, so my property is 1966. That fence line had been there since the previous owner. So I tore down the wooden fence when I bought the property, but I left those posts there. So it's still in the exact same spot. So basically my fence was not brand new. It was, I improved on what was there because I left the posts. And I said, look, this is where my fence was. Your string is actually over where my fence was. This is on my property. So once again, I asked them to, bring the homeowners down, and Vicky came down with a survey and she just kept on saying, look, this is our property. This is our property. And I said, it's not, this is my property. And the fence was my personal property. And we just kind of argued back and forth. And then I went in, and then you'll see the multiple tests where I said, you need to agree, before your fence workers agree that you're responsible for this fence. You're responsible because they're, putting it on the property line. You're responsible for the maintenance of it. Through Thurston County, I understand there should be a 6-inch setback. And I said, you need to move your fence back onto your side, which they did. They did just a couple sections. They did move in about, I think, 10 inches. And so we sent multiple texts back and forth. And then I said, I need you to agree that you guys are responsible for this. And then in that, I listed, you agreed that you should have never done it. You agreed to pay for it. And in that text, she just put noted, which to me, if she disagreed with anything I was telling her, as in you agreed this was a mistake, you agreed to pay for it, her response should have been, I never said that. And so they continued to build the fence. At one point, I said, where are my wooden posts? They had put them up on their trash trailer. The guys threw them back in the yard. And so you have the pictures of all that. So just basically, they tore down my fence when I wasn't there. I never got notice for it. And I just want to be recovered for the value of the fence that they tore down. I think that's the shortest version I can give you. Sorry. Okay, so what I will add is, so we've tried to do mediation twice. That didn't work. So 3 days ago, I was pulling my gate shut and Karen dropped off Vicky. Vicky was getting out of the passenger side. So she was literally from here to that wall to me. And I said, hey, can we just talk about this? Can we work through this? There's no reason we need to take this to court. You agreed you would pay. You would agree that, that was my damages. And she said, we don't owe you anything. Sorry, I actually wrote this down. So I would like to, I ran into Vicky, tried to resolve this again. She ended up telling me that she pointed to the front yard of my house, and I have pictures of it. She said, we own that tree. There's a Douglas fir tree in my front yard. She said, we own that tree. She pointed to my house and she said, we own up to the side of your house. She said, we own the land that fence was on. So it wasn't your fence, it was mine. And I said, all of this could have stopped if you'd just given me a certified letter. And Vicky's response was, that was our land. We didn't send you a certified letter when we put solar panels on our house. We didn't send you a certified letter when we painted our house. We did not need to send you a certified letter when we tore down the fence because it's our property.
And who wants to speak, Ms. Romo or Ms. Nelson? Oh, you're muted.
I'm Vicky, and I will speak, Your Honor.
All right, so let me focus on what I'm understanding the primary issue to be here. Is it your position that the fence that Ms.
Lieveling, sorry.
Ms. Lieveling, you need another E in there.
Yeah.
Ms.
Yeah, no, they
Lieveling
spelled it
is
wrong.
claiming damages for is actually your property since it was on your property. Is that your position?
No.
Okay, was the fence on the property line? What's the
Yes.
story?
Yes,
Okay,
on the old historic property line, which Thurston County sent a letter to Joyce Nevling, us, our property owners, the adjacent property owners of Eric and Barbara, and also our other neighbors. Thurston County's position is that the property line, even though it was historic, because of a lawsuit with the other neighbors, pushed the boundary lines. We have a legal description not claiming any of the property on the dispute. But until Thurston County receives a conveyance stating that, it continues to be a cloud on both of our titles, both of us having overlap ownership, and both of us continuing in this kind of a dispute until we have a boundary line agreement. That's what I
Okay.
hope gets resolved here.
all right, well, that's the one issue we can't resolve here because there's no authority in district court to resolve boundary lines.
Exactly. This is the wrong place to be doing it.
So
So
this has
to-
nothing to do with,
Okay, yeah, I'll come back to that.
sorry.
Okay, so we can ignore the fact that there's a boundary line dispute.
Correct.
If that's not a basis for taking down the fence. If neither party is going to argue that, no, we own the fence and we had the right to take it down, I'm specifically the defendants, if that's your argument, then I can't resolve that. That has to go to Superior Court. If you want to argue that it was your property and you had the right to take it down. Right now, if I remove that and say, okay, the fence was a boundary line fence and you took it down, and then we'll proceed as to whether it was appropriate for you to take it down. So you want to tell me, Ms. Romo, what your theory on that is?
Yes. We had sent notice to our neighbors that we were replacing the old fence, the wooden fence, because panels had been falling off. We
Okay,
would,
and by neighbors, you mean Ms. Lieveling?
yes, she was one of our 4 neighbors.
Okay, so the fence is more than just the property line of you and Ms. Lieveling?
Yes.
Is that
Correct.
right?
Correct. We are dealing with 4 neighbors.
Okay, and 4 fences.
And it happens to be just 3 fences between out of the 3 of the 4 neighbors. The 4th neighbor, it's just T-bars, not a fence.
Okay, all right. So you sent notice via text or
Yes.
some other way?
Text.
And Ms. Lieveling indicates that I think, as I understand it, she had blocked texts from you and Ms. Nelson last summer. Is that right?
It was a surprise, and I did not know that until we were standing there with Bonnie, the witness, Joyce, telling us that she had blocked it. And that was the first I had heard of it.
Okay, so you'd sent, how many texts do you believe you sent to Ms. Lieveling?
I sent her the one text that I sent also to our other neighbors that had fences. And one of the neighbors, I did not have their text number, so I sent it in a condolence letter to them, and I talked to them personally.
Okay, so Ms. Lieveling, you just sent her one text, is that right?
Explaining that we were putting in a replacement fence, that we would cover 100% of the cost, and that she had the choice if we would pay for the removal of the old material.
Okay, and you sent that text when?
That text was sent. March. I think it's in Joyce's. Let's see. March 13th, 2026, notified text to our 4 neighbors that fence replacements scheduled to start March 26th. Karen and I are paying for the replacement of the wooden fences between us. And I named all 3 of the fences, Neveling, Moe, and Ramirez. 2 of the wooden panels of the 3 between Neveling and our home blew down. We are clearing the path along the wooden section, continuing past the T-post, the bamboo mesh, the wire fence, and from the street to the pressure-treated post by the huge wall of the privet before our garden. The old wood panels and post will be removed by Cool Cat Fence Company. We can have them bundle your bamboo mesh, roll the wire, and leave the T-post for you. There was no reply to that email.
Okay, and was that sent with a receipt request? Did you
It was
see
a
that?
text message.
Right. So did it show that it was delivered?
Yes.
It couldn't be.
Okay, so it said delivered underneath. your
There was
version of
no,
it.
when I send a text, it'll tell me in red off to the side if it's,
It fails.
if it failed. It did not. I had no
Okay.
indication. And again, on 3/26, when they were installing the fence, it was the first I had heard that she did
Right.
not receive it. And then I read it to her and Bonnie while they were there. So that is their notice also.
Okay,
After the fence store.
all right. And so do you have the text on your phone?
I have it on mine, and Joyce had me do a screen print and mail it to her certified mail, I think. And she
Okay,
also
and
has
does
it, and it's in the evidences.
Okay. Does it say delivered underneath the text?
It doesn't say not delivered. I mean,
It just
it's
says
just like
failed.
my,
Yeah, it just
my-
says, it just says failed if it doesn't go through. It doesn't say delivered. I mean, on some phones it does say delivered. I don't know on hers if it does or not. I don't think hers says delivered. I didn't say, it says failed.
Was it sent on an iPhone, Ms. Romo?
yes, I think I
An
have-
old iPhone,
Yeah.
yes.
Ms. Lieveling, is yours an iPhone?
Mine's an Android, but
Okay.
here's the text right here. And you can see it doesn't say delivered, it doesn't say failed, it doesn't say anything.
Right,
I never
okay.
received it.
So Ms. Lieveling claims that she did not receive the text, and Ms. Romo says she wasn't aware that Ms. Lieveling was blocking their text since last summer. Should they have been aware of that? Was that something you?
Yes, I
just-
sent them a 4-page email ending the friendship and explaining, do not ever contact me again. And I've never seen them since last summer. So they knew friendship was done, do not contact me.
Okay, and your immediate neighbors?
Pardon me?
Your immediate neighbors?
Yes,
Okay. And you sent that like last July or something?
last summer of 2025, the last time we went hiking, I sent them.
Okay. So between then and March, do you see them? You live right next door to each
Yeah,
other
no,
and you
but
don't see each other?
I had my privacy fence that they tore down, and then my whole front yard is 6-foot tall ivy.
Mhm.
And then I have a gate, and so their house is actually across the street, but over one, then they have a guest house right next to me. So the pictures that they sent in for evidence circling the fern, that's actually their guest house, that's directly next to me.
And that's where the fence was?
Yes, the fence was there.
And Ms. Romo, your thoughts as to not going over and knocking on Ms.
Neveling.
Ms. Lieveling, Joyce's door
There you go.
and at some point in saying, hey, we're thinking of taking down the fence. I know we're not supposed to be talking, but I thought I should clear this with you first. What was your thought on that?
Talking with Joyce, I thought it was very clear that she had moved on, and we were fine with that. However, the boundary line on January 14th, Thurston County sent a letter to the four of us, Joyce, us, Karen and Vicky, our neighbors next to Joyce, Eric, and Barbara Imperio, and to Maria Ramirez, our other neighbors. So all four neighbors received a letter from Thurston County explaining the boundary line survey that was attached that became the prevailing survey because of the settlement through the courts of where the boundary lines agreed to.
Okay, but let me go back to what we talked about earlier, which is you're not asserting authority over the fence because of a boundary line issue. You're agreeing right now for purposes of this case that the fence was on the property line or on Joyce's property, and you proceeded to remove the fence. Am I accurate in that?
I'm sorry, Judge. I was trying to respond to the fact that it was not unusual for her not to give us a reply, either to my text, or from Thurston County, or from a real estate attorney trying to explain the situation of the boundary line fence.
Okay, and by that, was there a meeting with an attorney who offered to meet with Joyce, or what's the story there?
Yes.
Would you like my version?
Okay, I'll come. So was there a meeting set up or something? I couldn't tell what you meant.
There was a letter sent to explain how we can resolve this issue.
Amicably.
Yes. And we're trying to operate in good faith, trying to have clear communications, and not coming from us, but from Thurston County or from a real estate attorney to help us resolve. In the meantime, the fence we wanted to replace
as it was,
offer as it was without contesting the line. So we're just dealing with replacing the old fence and giving her the option of the material, either to keep it or to have us take it away. Not getting a reply, we went ahead and just left the material there, and then dealing with it on that day. Just trying to do the best we could to get the replacement fence in place. So we
weren't trying to encroach. We were just trying to replace a fence.
Yeah, the whole my property and trespassing, that's to be resolved by following the guidelines of what the assessor's office is saying, what we're paying property taxes on, and what the attorney.
But that's nothing to do with
But
today.
that's, yeah, the fence is replaced. We have a privacy fence there. And the materials, we offered to pay for the materials for the materials, but not to give her cash in her pocket for
us replacing a brand new fence.
For us replacing the fence, paying 100% cost.
Yeah.
So it looks like the letter from Ms. Wood went out in June, so subsequent to the taking down of the fence. Does that sound correct?
Yes, Ms. Wood was just for trying to get the boundary line corrected with all the neighbors together, all three neighbors doing it in one fell swoop. And all the neighbors agreed except Joyce. So we just moved on and did it with just the back neighbors who were building a home. And we didn't want to hold up their process. So we did get an agreement with them as the original, where the original fence line was there, it still is. And that is the line.
Okay.
We have
All right.
agreed.
Okay, yeah, and my point in looking into this is the issue of communication.
Yes.
Yes.
That's going to be, I think, important in deciding whether there was authority to take down the fence, is whether that had been properly communicated. Unless the position of Ms. Romo and Ms. Nelson is that the fence was their property and they had the right to do with it regardless. But I don't think that's your position. Am I correct?
That is correct, Honor. We showed the picture on our photo number 1. The wooden fences, the 3 8-foot panels, those are ours, not disputed. You can see attached to it is the bamboo
And the
and on the other end of it, on photo number 2, it shows the other end where the wire
has been
4-foot wire one has been reattached, so that the integrity of the fence is in place where it was. We replaced with the metal, and I know that that was not what she wanted. She wanted to keep her fence, but we did not have any indication from her until after the fact. So she has her materials, and we tried to pay for the materials through the fence company, sending a check, which it's not materials that she wants.
She wants cash. And
okay, so the notice to Joyce that you were replacing her fence was via text, which Joyce claims she didn't receive because texts are blocked. And you have the indication that you sent it, but no indication that it in fact was received, other than it doesn't have the have to try again stamp on it. So there was no conversation about this other than the one text. I want to make sure I understand this. Ms. Lieveling, is that correct?
You can just say Joyce. And can I just add, they sent a text to the neighbor to their south that they had the property line fight with for 2 years. They waited until he responded from that text before they put their fence up on his side. They didn't wait to hear from me.
Okay. So there's been no communication, and you did not receive a text that you're saying under oath.
I've not seen or talked to them since.
All right. And Ms. Romo, I think I've asked you that question before, and you agreed it was the one text and there's been no other communication.
That is correct.
That is correct.
She has not responded, and I've not seen evidence of her responding to other.
Okay.
But I did read. We did read it to her on the day.
On the 26th, as the fence is being taken down.
As
Is that
witnessed.
correct?
It was already down.
Yeah.
And we sent copies of it.
All right.
After it was done.
So let me just say this. So the amount I asked for is actually less than my out of pocket, and I'm happy with that. I just want to cover my court cost, my copying, the certified letters, plants that they killed.
Detail your costs for me, please.
Oh, gosh.
Yeah.
Okay, I think this is the first one. Okay, copies were $13.13.
Okay, let's leave copies out of it.
Pardon me?
Leave copies out of it. Keep
Oh.
going. Tell me what your costs are.
Do you want the fence? What is 2,900? And that's what I'm asking for, 2,907. I did not pay that. That's on hold.
You did not pay that
That's the fence company estimate.
to do what? Replace your fence?
Yeah, that's his value of what it would cost to, what the fence value was $2,907.
Okay.
Then I have the two ferns is, sorry, the lilac plant that was killed is $159.45. The two ferns are $57.42. You don't want copies. How about all the certified letters I had to send them? Nope. Okay. And the court fees was 50. And then the service document was $14.03.
Thank you.
That's it.
All right, and Ms. Romo, anything else?
None of those costs has she put out for the fence to be, for the fence. Those are just going to go into her pocket.
Right.
Fence
Yeah.
doesn't-
Other,
yeah.
I understand that argument. I hear what you're saying.
Yeah. The
So
fence
your
doesn't need
position
to
is
be-
you've put up a nice fence. You've reconstructed hers to the degree that it could be. And any addition she gets is going to be financial, not by way of fence construction. That's
Exactly.
correct.
Correct.
Thank you.
all right. Yep.
You didn't start it.
We're happy to pay for her ferns.
All right. And before I say anything else, I do want to explain myself. The reason I've been having such a problem with your name is we have it as NEVA.
I know, yes, NEAV.
So if I saw that it was NEA,
Yeah, that's okay.
I would have had it.
It's been my entire life. I married a Skinner. I should have kept that last name.
All right, with the parties agreeing that any determination as to ownership of the property isn't an issue for this trial, and that the sole issue was their authority to take down the fence, I'm going to find no, since there wasn't sufficient communication to Ms. Neveling, even though there was an attempt to communicate. Apparently, Ms. Romo and Ms. Nelson are unaware that their texts have been blocked, but regardless, they didn't make any effort to go over and personally say, here's what we're intending to do. What are your thoughts? And without that authority, I find that the taking down of Ms. Neveling's fence, even if it's replaced by something more effective and better aesthetically, can't take down somebody else's property without their authority. So I'll find judgment for Ms. Neveling in the amount of the estimated value of the fence and the damage to the plants and the principal sum of $3,123.87. And then with the cost of filing and service, the judgment is $3,187.90. And that does not require Ms. Neveling to replace her fence. It's just the liability for taking down a fence without proper communication. Ms. Neveling is present in court. We'll give her a copy of the judgment, and for Ms. Nelson and Ms. Romo, you can access that judgment through your civil file at district court. All right. Thank you all.
Thank you so much.
Thank you, Your Honor.
Thank you, Judge.
You're welcome.
Well, that's how that cookie crumbled. Yeah, and Denisha, we didn't watch that last hearing here, but I know I've seen it on other channels. I'd been saving that one specifically for tonight all week long. That happened on the 21st, a couple of days ago. So it was a small claims court thing that happened in Thurston. I kept my eye on it. Thank you all for coming by and chatting. That was fun. I don't know. I don't know how many times to say thank you, and thank you. Miss Good Kitty, thank you so much. She has a very good idea to the first lady that had issues with her water. Lady, hey, how about paying your bill? For God's sake, and figuring out how bills work. Gee, can you believe there's people that are that age that act like they still don't know how things work? I mean, I get it. there's a lot of us out here who live in residences where the utilities may not be in our name for one reason or another. There's not many utilities, and if you're not leasing, if you own, they don't really care what the name on the bill says, as long as you pay it on time. And I assure you, if you pay the bill on time for that location, they will leave the utilities on for you all day long, every single day. All right, I have it on good authority. Ladies and gentlemen, look at these names right here. Miss Good Kitty is right there. And all of these people, Speck, Ron Ann, Barry Adams, Mama's in there somewhere. I know she is. Hey, look, right there. There's Mama. Fat Boy, Wendy Greek, Terry Bosworth, Alex Damon, Ali Song, Stephen, Darth Stevens, sir, Mortimer, Coolest Cat, Straw Carpenter, Soldier of Providence, Dobby, great to see you, X25, Eileen. Hey, I heard there was Holland raid somewhere along the line, and I didn't pause to say thank you all so very much. I think that was somewhere around 15-20 minutes ago. Thank you all for coming by. Be kind. If you hadn't seen everything we had to offer here, rewind. There are time codes in the description so you can jump right to the spot you want to go. I am your lone wolf Oozville. I've been putting together all of these little compilations. This is the beginning of a new week, ladies and gentlemen. Get ready. We got a whole new set of court cases coming. Same wolf time, same wolf channel, all week long. Sunday. Get ready for Monday. The work week, and it begins again. Actually, I don't know. For some reason, Mondays not a holiday, is it? Oh, we're moving close in, like Labor Day, right? Is that the right holiday? Yeah. So, like, let go of the rope says, get ready to rock and roll. And for me, to you, thank you so very much for hanging out. I'll have more stuff for you tomorrow. Come on by and hang out. We'll talk then. For now, I'll just say thank you. I'm your lone wolf Oozville. I'm your host for this little get together. I'm your curator for this little archive. And for now, I am out. Oh, thank you, Eileen. Labor Day is a week from tomorrow. Cowlitz, yeah. Bye. Yeah. Killer. And remember, only you can take a bite out of crime. Bye. Now don't stick around. I have nothing else. Bye. Killer.